your time, and I do oppose this bill.
Thank you. The next opponent.
Chairman Murphy, members of the committee, good morning. My name is Bill Gallagher. That's G-A-L-L-A-G-H-E-R. I am the chairman of the Montana Public Service Commission and address you today in that capacity as their representative. The Public Service Commission voted 5-0 to oppose Senate Bill 423. I should point out that 2 of those in opposition were strictly because it requires amendment. The reason expressed by the remaining majority of the Commission for its opposition is that the PSC is not the appropriate agency to assume the role of the state licensing authority. The Commission has a full plate of utility regulatory issues with numerous important cases either before us now or expected in the near future. Adding the role of state licensing authority as contemplated under this bill would distract the agency from its core mission. But if the legislature determines that the PSC is the appropriate agency, we have identified the following concerns with the bill as written. First, the courier delivery system is problematic. States are preempted by federal law from regulating motor carriers of property. Our regulatory authority now comes through exceptions in that federal law. For example, an exception is the regulation of taxis, household goods. But the transportation of business property is not within that exception, and so we do not and cannot regulate the transport of business property. If therapeutic marijuana is property under the eyes of the federal government, we cannot regulate the transportation of therapeutic marijuana, and amendment to other state law may be necessary to bring that within that definition. The bill lacks specific standards for granting licenses such as need. The bill is replete with direction with regard to prohibitions, denials, and revocations, and we suggest that it might be possible to pattern the grants of licenses after the certification process we use for other motor carriers. 3, the uncertainties surrounding the number of registered cardholders who will remain and be added once the bill takes effect makes it impossible to estimate with any accuracy what the PSC's costs would be for administering the licensing authority responsibilities. Public Service Commission funding during the ramp-up of the program is a definite concern, especially since it would not be appropriate for utility ratepayers who are currently funding the Public Service Commission, from whom regulated utilities recover their PSC funding fees, to foot the bill for any part of this new program. Moreover, if the program fees are initially limited to therapeutic marijuana, there may be and probably would be a lag between PSC incurring costs and assessments and the recovery of the fees. This would be true in the second year also, because of any leftover funds must be returned to the general fund under the current bill writing. We propose that SB 423 provide funding for this new program out of the general fund, at least for the first biennium. Keep in mind, committee members, that this is a short time horizon, a heavy front-end load regulatory process that would have to be ramped up very quickly, and we are a small agency with just 34 full-time employees, and we would definitely need additional staff to meet the requirements of the bill. Although licensed growers and product manufacturers would be nonprofit organizations under this bill, there is no limit on compensation for the owners and managers of those entities, and perhaps the committee would consider those limitations. On Section 10, lines 8 through 16, this list, it's a list of who can cultivate or manufacture therapeutic marijuana, includes registered cardholders, growers, and product manufacturers, but does not include the personal production assistance contemplated, and we simply ask, should this list include the personal production assistance? In Section 18, lines 14 and page 19 on line 10, the provisions both say that the PSC may impose fines and penalties pursuant to law or rule. However, the bill is not specific as to whether the PSC must go to the district court to collect a fine as required currently in Title 69, and it is also not specific as to how much the PSC may fine. In Section 17, lines 17 through 19, the provision requires the PSC to adopt rules, rulings, and findings as necessary for the proper regulation and control and for the enforcements of Sections 1 through 40. However, Sections 1 through 40 include the DPHHS cardholder sections, and we simply ask, is the Public Service Commission responsible for enforcement of the law as it pertains to the cardholders? And we do not think that was contemplated. Finally, on page 46 of the bill on line 22, the section says that a license or registrant must surrender his license or registration if he is convicted or pleads guilty to a DUI under certain circumstances. The court must then forward the surrendered license or registration and a copy of the conviction to the Department of Revenue. And we suspect that that was a holdover, if not a Freudian slip, suggesting this might be the Department of Revenue's bailiwick. But if you are going to ask the Public Service Commission to regulate, that error should be changed. In conclusion, I thank you for your time. The Public Service Commission is recommending a do not pass on SB 423 for the reasons enumerated, and I thank you for the opportunity to testify.
Thank you, Mr.
And Mr. Chairman, I have brought with us our Bureau Chief from Transportation and also our Transportation Lead Attorney, as well as a couple of other commissioners in the event that you have questions with regard to our role.